case number SS 70 of 2021, State versus Ephraim Falapizza and Rorich.
Who's on record for accused 1?
Yes, Court, please, my lord. My lord, I confirm my appearance for accused number 1.
Accused 2?
My lord, I confirm my appearance for accused number 2.
Thank you. The matter was
just put on record, it's only for basically a day or two, my lord, for circumstances that you know. I'm not available for the trial, but I am available for this week for whatever transpires.
Right, thank you. The court proceeds then to read down the ruling for which this matter was postponed for. Paragraph 1. This is an application in terms of Section 85(1) of the Criminal Procedure Act 51 of 1977, which will hereinafter be referred to as Act 51 of 1977, brought by the accused against the intended charges upon which the accused are to be arraigned. Paragraph 2. The state intends to charge the accused with 5 main offences and 3 alternative counts. The 3 alternative counts relate to the 2nd to 4th counts, and including the 5th count. The charges are as follows. A. Count 1, kidnapping. B. Count 2, the crime against humanity, namely murder read with Section 232 of the Constitution, relating to the death of Eustace Madikela, allegedly committed on 15th of February 1982. Alternative to count 2 is murder read with provisions of Section 91, 92, 258 of Act 51 of 1977. C. Count 3 is a crime against humanity, namely murder read with Section 232 of the Constitution, relating to the death of Peter Matabane, allegedly committed on 15th of February 1982. Alternative to count 3, murder read with the provisions of Section 91, 92, and 258 of Act 51 of 1977. D. Count 4 is a crime against humanity, namely murder read with Section 232 of the Constitution, relating to the death of Fanyana and Chlapo, allegedly committed on 15th of February 1982. Alternative to count 3, murder read with the provisions of Section 91, 92, and 258 of Act 51 of 1977. E. Count 5 is a crime against humanity of apartheid read with Section 232 of the Constitution, in that on 15th of February 1982 the accused killed Eustace Madikela, Peter Matabane, and Fanyana and Chlapo. Paragraph 3. This court has allowed the family members of the deceased in the matter and COSAS to intervene as amicus curiae in respect to the objection raised. Paragraph 4. Accused 2, who is joined by accused 1 in this objection, takes issue with reference to the main counts set out in counts 2, 3, 4, and 5 on the basis that the state's right to institute a prosecution against the accused on the mentioned charges has lapsed in terms of Section 18 of Act 51 of 1977. Accused 1 has in addition objected to the title of the National Prosecuting Authority, who will be hereinafter referred to as the NPA, to prosecute, given that the NPA and the Government of South Africa committed gross misconduct by engaging in political interference in the cases referred by the Truth and Reconciliation Commission, which will hereinafter be referred to as the TRC, to the NPA. Paragraph 5. The state contends that the base of the charges on counts 2, 3, 4, and 5 arise from the accused conduct as being part of a systemic attack or elimination of political opponents of the apartheid regime, and further that they form part of an institutionalized regime of systemic oppression and domination by one racial group over other racial groups with the intention of maintaining that domination. The avenue of the state has chosen to pursue this prosecution in this matter in terms of Section 232 of the Constitution. The prosecution of the accused was instituted during 2021, which is approximately 40 years after the alleged crimes are alleged to have occurred, namely on the 15th of February 1982. Paragraph 8. The accused contend that Section 18(1) of Act 51 of 1977 provides that the right to institute a prosecution for any offence other than the exceptions referred to in paragraphs A to J shall lapse after the expiration of a period of 20 years from the time when the offence was committed. As a result, counts 2, 3, 4, and 5 do not fall within the ambit of the offences excluded from the operation of Section 18, subsection 1 of Act 51 of 1977, with specific reference to Sections 18, subsection 1, A to J. Paragraph 9. Section 18(1) of Act 51 of 1977 was amended by Section 39, Schedule 2 of the Rome Statute of the International Criminal Court Act 27 of 2002, which will be referred hereinafter to the ICC Act, to introduce Section 18(1)G of Act 51 of 1977. On 16 August 2002, the crimes of genocide, crimes against humanity and war crimes as contemplated in Section 4 of the ICC Act were added. Prior to the relevant amendment, there was no Section 18(1)(g) or any similar provision. The contentions of the accused are as follows. Paragraph 10. The accused contend that the state have an unsurmountable problem regarding the charges arraigned against them, and that the state is relying on customary international law and not the offence of a crime against humanity created in terms of Section 4 of the ICC Act. Paragraph 11. The accused argue that Section 18(1)(g) of Act 51 of 1977 provides for an exclusion from the general prohibition to prosecute with reference to prosecutions in terms of Section 4 of the ICC Act and the amendment that introduced Section 18, subsection 1, subsection G, and that the amendment only came into effect on 16 August 2002, which is more than 6 months after the state's right to prosecute has lapsed. Paragraph 12. The accused state that even if it is found that Section 18, subsection 1, subsection G of Act 51 of 1977 is also applicable to prosecutions in terms of the customary international law, which is disputed, the right of the state to prosecute has still lapsed on 14 February 2002. Paragraph 13. It was contended there is no provision in Section 18 of Act 51 of 1977 for any revival of the right to prosecute relating to a crime against humanity after it has lapsed, resulting in no tribal issue between the state and the accused relating to the charges on counts 2, 3, 4, and 5. This is because the legislature specifically dealt with the issue of the revival of certain offences that have lapsed prior to the amendment of Section 18, subsection 1 of Act 51 of 1977. In that Section 18, subsection 2 of Act 51 of 1977 states as follows, and the court quotes, "The right to institute a prosecution that in respect of any offences referred to in subsection 1, subsection EA, and subsection F has lapsed before the commencement of the prescription in civil and criminal matters, Sexual Offences Amendment Act 2020 is hereby revived," unquote. Paragraph 14. It was argued that the provision for the revival of certain offences that have lapsed prior to the extension of the exclusions provided for in Section 18, subsection 1 of Act 51 of 1977 were limited to 2 subsections or categories of offences, namely those referred to in Section 18, subsection 1, capital subsection E, capital A, which are the crimes of bribery and corruption, and those mentioned in Section 18, subsection 1, subsection F of Act 51 of 1977, which are sexual offences. Paragraph 15. It was argued that because Section 18, subsection 2 of Act 51 of 1977 was introduced in 2020 by Section 3 of the Prescription in Civil and Matters Sexual Offences Amendment Act 15 of 2020, which is referred to as Act 15 of 2020, that it can be inferred that prior to 2020 there was no provision for revival of offences where the right to prosecute had lapsed in terms of Section 18 of Act 51 of 1977. Furthermore, that during 2020, when the legislature considered and decided to amend Section 18 of Act 51 of 1977 to provide for the revival of certain offences that had already lapsed, Section 18, subsection 1, subsection G of Act 51 of 1977 relating to crimes against humanity existed and was part of Section 18, subsection 1 of Act 51 of 1977. Paragraph 16. The accused contend that when interpreting Section 18, subsection 1, subsection G of Act 51 of 1977, there is a presumption against retrospectivity. Reference was made to the Constitutional Court case of S versus Mhlungu others, 1995, Volume 3, Essay, page 867. Paragraph 17. It was argued that any court must interpret the Section 18, subsection 1G so as to render an interpretation least harsh to the affected persons. Paragraph 18. It was contended the wording of Section 18, subsection 1G is subjectively clear, and that the legislature elected to only refer to offences contemplated by Section 4 of the ICC Act, of which a crime against humanity is included, and not to refer to offences in terms of the international common law, and not to provide for the revival of any of the offences referred to in Section 18, subsection 1G of Act 51 of 1977. Paragraph 19. It was argued that the state's contention that a proper interpretation of Section 18, subsection 1, subsection G of Act 51 of 1970 is to include all crimes against humanity, including crimes in terms of the common international law, read with Section 232 of the Constitution, is clearly wrong and should be rejected. It was argued that if the legislature intended to include the crime against humanity in terms of the customary international law, the legislature would clearly have done so. The fact that the legislature did not include it is because it clearly did not intend to. Paragraph 20. In addition, it was contended that the general rules and principles relating to the interpretation of statutes do not support an interpretation to broaden the ambit of Section 18, subsection 1, subsection G of Act 51 of 1977. Paragraph 21. Accordingly, the accused argued that the charges as formulated in the present indictment with specific reference to the main counts on count 2, 3, 4, and 5 do not fall within the ambit of Section 18, subsection 1G of Act 51 of 1977, and this court should uphold the objection in terms of Section 85 of Act 51 of 1977. As regards the contentions of the state and the amicus, paragraph 22, the state and the amicus make the following contentions, namely, paragraph 22, A, the customary international law binds the Republic even in instances where South Africa has not ratified an associated treaty in terms of Section 231 of the Constitution. B, Section 233 of the Constitution requires any court interpreting legislation to, and the court quotes, prefer any reasonable interpretation of the legislation that is consistent with international law over any alternative interpretation that is inconsistent with international law, unquote. C, international law is comprised essentially of treaties and customary laws. Treaties bind those states that are parties to them. Customary international law, on the other hand, is a collection of rules that have been accepted and practiced by the international community. Rules of customary international law are binding on all states. According to the International Committee of the Red Cross, which will hereinafter refer to as the ICRC, customary international law derives from a general practice accepted as law. Such practice can be found in a variety of sources, including national legislation, regional and international instruments, domestic and international case law, and scholarly works. It was argued that Section 7, subsection 4 of the implementation of the Geneva Convention Act 8 of 2012 recognizes prosecutions of international crimes under Section 232 of the Constitution, in that, and the court quotes, nothing in this act must be construed as precluding the prosecution of any person accused of having committed a breach under customary international law before this act took effect, unquote. D, the amicus contend that much of customary international law has evolved from norms proclaimed in international human rights instruments, which have their basis in the United Nations Charter, the Universal Declaration of Human Rights, and other treaties of a universal character. Furthermore, it is contended that to qualify as customary international law, an international norm must meet two requirements. It must qualify as a constant and uniform uses, and must be followed from a sense of legal obligation, namely opinio juris. Whether a norm qualifies as a norm of customary international law is a question to be decided by court through the application of the criteria of uses and opinio juris. E, reference was made to the restatement of the Foreign Relations Law of the United States, 3rd, 1987, which will hereinafter be referred to as the Restatement 3rd. The Restatement 3rd characterizes some of the rights in the Universal Declaration of Human Rights as customary international law, and lists the following practices as violating customary international law, namely genocide, slavery, murder, or causing the disappearance of individuals, torture or other cruel, inhuman, or degrading treatment or punishment, prolonged arbitrary detention, systemic racial discrimination, and consistent patterns of gross violations of internationally recognized human rights. The amicus contend that the Restatement 3rd asserts that repeated failures to punish violations of rights protected under customary international law may constitute government condemnation of such acts, especially if such acts are repeated by officials and no steps have been taken to prevent them or to punish the perpetrators. F. It is right that a court may find the accused guilty of a crime only where the conduct was recognized as a crime at the time of its commission, which is referred to as the jus praevim principle. It is a known fact that crimes against humanity evolved under customary international law and were first charged under the Nuremberg Tribunal Charter of 1945. The United Nations General Assembly endorsed the concept of crimes against humanity in 1946. Crimes against humanity are defined by a set of inhuman acts committed in a particular context, namely as part of a widespread or systemic attack directed against any civilian population. It was contended that in the matter in casu, the accused committed his acts as part of a widespread and systemic attack against black civilians and opponents of the regime. G. The state contends that the charges have been formulated to identify two separate constitutive elements of crimes against humanity. These are 1. The general contextual elements of the crime, which refers to a regime of systemic oppression or attack, and 2. The specific underlying attacks that an accused committed with the requisite intention referring to the murder, persecution, or other inhuman acts. Paragraph 23, as a result, both the state and the amicus contend that counts 2, 3, 4, and 5 are valid and can stand. In evaluating this ruling, paragraph 24, the accused are charged with core offences based on customary international law, read with section 232 of the Constitution, and not in terms of section 4 of the ICC Act. Accordingly, this court must determine whether counts 2, 3, 4, and 5, which are based on the alleged contravention of the customary international law, read with section 232 of the Constitution, can be used as a self-standing basis for institution of a prosecution. Paragraph 25. The accused have a right to object to an indictment by the state, which is provided for in section 85 of Act 51 of 1977, provided that an accused has stated the grounds upon which the objection is based. Paragraph 26. The essential objection raised by the accused that the crimes against humanity referred to in counts 2, 3, 4, and 5 do not fall within the ambit of the offences excluded from the operation of section 18, subsection 1 of Act 51 of 1977, and have prescribed. Paragraph 27, as argued by the state and the amicus, international law consists of specific treaties or conventions that specific countries consent to, which binds them, and then there's customary international law that is binding on all countries. As a result, serious human rights violations are criminalized and can be prosecuted under both conventional international law and customary international law. In terms of the Constitution, both sources of international law form part of South African law. Paragraph 28, Section 231 of the Constitution governs the domestication of conventional international law, providing that once South Africa has signed a specific treaty of convention, it becomes law in the Republic, when it is approved by Parliament and enacted into law by national legislation. It also states that the Republic is bound by international agreements which were binding on the Republic when this Constitution took effect. Paragraph 29. Section 232 of the Constitution refers to the domestication of customary international law and states that, in the court quotes, customary international law is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. Paragraph 30. As a result, under South African law, crimes against humanity can be brought by the state either in terms of conventions that South Africa has signed, ratified, and duly implemented, example the ICC Act, or in terms of the customary international law as stated by Section 232 of the Constitution. Paragraph 33. Customary international law is a source of international law developed through state custom or practice, as stated previously. In effect, it is the common law of the international legal system, and as stated previously, a custom becomes a rule of customary international law where it is a sufficiently widespread practice adopted by states out of a sense of legal obligation. In the matter of Colombia versus Peru, and the head and the notes will set out clearly the reference, the International Court of Justice, which will be referred to as the ICJ, stated that for a practice to become a rule of customary international law, the practice must be constant and uniform. Paragraph 32. Customary international law establishes a duty to investigate and prosecute international crimes, such as extrajudicial killings, torture, and enforced disappearances. Paragraph 33. Customary international law was recognized as being of direct application in South Africa even before the advent of the Constitution. In the matter of Nduli and another versus Minister of Justice and others, 1978, Volume 1, Essay 893, the Appellate Division, as it then was, as per the judgment of Chief Justice Rumpf, accepted that customary international law was, subject to it not being in conflict with domestic law, directly operative in the national sphere. The learned Rumpf CJ noted that customary international law would have to be either universally recognized or need the assent of this country. Subsequent judgments, namely Interscience Research and Development Services, Pty Limited, versus Republica Popular Mozambique, which is, the citation is 1980, Volume 2, Essay, a Transvaal Local Division decision, and S versus Betani, 1988, for 4, all South African reports at page 88, the Cape Provincial Division decision departed from this interpretation. However, in the matter of Petane, the court held that in that case, the distinction between universal and general recognition of customary international law made no difference, and the court held that, and the court quotes, where a rule of customary international law is recognized as such by international law, it will be so recognized by our law, unquote. Paragraph 34. In the matter of Law Society of South Africa and others versus President of the Republic of South Africa and others, 2019, Volume 3, BCLR, page 329, the Constitutional Court decision held that, and the court quotes, our Constitution also insists that courts not only give a reasonable interpretation to legislation, but also that the interpretation accords with international law, and unless otherwise inconsistent with our Constitution, customary international law is law in this country, unquote. Paragraph 35. It is clear from the decision of Patane that customary international law has been an integral part of South African law long before the Constitution came into effect. Paragraph 36. Unlike treaties, no specific action is required to incorporate customary international law into the Republic's legal system. Its mere existence is sufficient, and customary international law automatically forms part of the law of the Republic unless it is inconsistent with the Constitution or an Act of Parliament. Paragraph 37. Apartheid was a system of racial segregation and discrimination that was formally implemented in South Africa in 1948. The system, rooted in the country's history of settler colonialism, was designed to maintain the domination of the white minority over the black majority. The apartheid regime, amongst others, enforced racial categorizations, segregation in all areas of life, and the disenfranchisement of black South Africans. Additionally, enemies or threats to the state were punished with imprisonment, kidnapping, torture, police and state brutality, and assassinations, to name a few. Paragraph 38. Apartheid was declared a crime against humanity by the United Nations General Assembly in 1966. It was placed beyond any statute of limitation, i.e. time bar, by an international treaty in 1968 and comprehensively criminalized under the United Nations Convention on the Suppression and Punishment of the Crime of Apartheid in 1973, which we'll hereinafter refer to as the Apartheid Convention. These sources all predate the crimes charged in the matter in KwaZulu. Paragraph 39. The transition to democracy, which culminated in the first democratic elections of 1994, involved negotiations between the apartheid government and liberation movements, resulting in our current constitutional framework that enshrined human rights and the rule of law. A key element of this transition was the establishment of the TRC in 1995. Paragraph 40. The TRC endorsed the position that apartheid as a form of systemic racial discrimination and separation constituted a crime against humanity, and that in this context, the state, in the form of the South African government, the civil service and its security forces, was in the period of 1960 to 1994 its primary perpetrator. Paragraph 41. The contextual elements of the charge of crime against humanity of apartheid incorporate the common elements of the definitions of the crime jointly under the Apartheid Convention and Article 7 of the ICC Act, which includes specific inhuman acts all committed as part of maintaining an institutionalized regime of systemic oppression and domination by one racial group over persons of another racial group. Paragraph 42. As far as the underlying acts of the crime of apartheid are concerned, both the Apartheid Convention and the ICC Act expressly list murder, inflicting physical and mental harm, arbitrary arrests, extermination, enslavement, persecution, torture, enforced disappearance of persons, and apartheid as examples of inhuman acts. Corny crimes against humanity have existed under customary international law for at least 79 years. Paragraph 43. It can be demonstrated that apartheid as a crime against humanity passed into customary international law prior to the crimes committed in the matter in KwaZulu, namely on 15 February 1982. Then the NAP, the National Prosecuting Authority, is entitled to proceed with such charges. Paragraph 44. The Constitution acknowledges and incorporates these pre-existing principles automatically without the need for specific legislative action, thus integrating the influence and relevance of customary international law within the South African legal framework. Therefore, even if these charges were non-existent offences in South Africa at the time of their commission, they were offences under customary international law, which have been an integral part of South African law pre-1994. Paragraph 45. South Africa would not be the first country to prosecute matters which occurred long after the commission of the crime. In Cambodia, for example, courts were established in 2006 to prosecute the senior leaders of the Khmer Rouge responsible for atrocities in Cambodia, and the trials began 3 decades after the commission of these atrocities. As regards the Constitutional Court decisions in this regard, paragraph 46, in the matter of S versus Besson, 2005, volume 1, essay, page 171, a Constitutional Court decision which the court will refer to as Besson 1, the Constitutional Court held that, and the court quotes, the state's obligation to prosecute offences applies to all offences committed before the Constitution came into force. It is relevant to this inquiry that international law obliges the state to punish crimes against humanity and war crimes. It is also clear that the practice of apartheid constituted crimes against humanity, and some of the practices of the apartheid government constituted war crimes, unquote. Paragraph 47. In considering Section 232 of the Constitution, the Constitutional Court in Basson 1, as per the judgment of Sachs J, confirmed that the rules of humanitarian law constitute an integral part of customary international law, in that it applies and has to, and the court quotes, be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law, unquote. Paragraph 48. The finding of the Constitutional Court in the matter of Basson 1 confirmed that crimes against humanity under customary international law can be prosecuted directly under Section 232 of the Constitution. Paragraph 49. In the matter of Basson 1, Sachs J raised three substantial constitutional questions in connection with the quashing of the charges against Mr. Basson. A. The first is whether the conduct charged could be categorized as a war crime as understood by international humanitarian law. B. If the answer is affirmative, the second question is whether and to what extent this could impose a special constitutional responsibility on the state to prosecute the respondent. C. The third is whether the quashing of the charges without reference to the fact that the prosecution of war crimes was involved manifested a failure to give effect to South Africa's international obligations as set out in the Constitution. Paragraph 15. Dealing with the first question as to whether the conduct alleged in the quash charges were war crimes, Sachs J referred to Casey's definition that war crimes are, and the court quotes, serious violations of customary or, whenever applicable, treaty rules belonging to the corpus of the international humanitarian law of armed conflict, unquote. Paragraph 51. Sachs J concluded that if the allegations in the Basson matter could be proved, it would be difficult to argue that they did not constitute war crimes. Paragraph 52. In considering the second question, Sachs J questioned whether if the charges could establish the commission of war crimes, which such a finding signify a need to take account of international law in determining the issues. In this regard, he concluded that the materials before him were sufficiently substantive to propel this question from the realm of the purely speculative into the universe of the real. Paragraph 53. In the matter of S versus Basson, 2007, Volume 3, Essay, page 582, which will be referred to as Basson 2, the Constitutional Court concluded that certain violations, such as murdering captives held by the security forces, fell squarely within customary international law prohibitions. And the court quotes, "What matters is that regard had to be had by all those involved in the conflict to intransgressible principles based on elementary considerations of humanity. There can be no doubt that the use of instruments of state to murder captives long after resistance had ceased would in the 1980s as before and after have grossly transgressed even the most minimal standards of international humanitarian law," unquote. Paragraph 54. In the matter of National Commissioner of the South African Police Service versus Southern African Human Rights Litigation Centre, 2015, Volume 1, Essay, page 315, the Constitutional Court confirmed that, and the court quotes, "The extent of our country's responsibilities as a member of the family of nations to investigate crimes against humanity lies at the heart of this case," unquote. Paragraph 55. In the matter of National Commissioner, the Constitutional Court held that, and the court quotes, "Crimes against humanity are criminalized under Section 232 of the Constitution," unquote. Paragraph 56. A reference in the matter of National Commissioner is clearly the crime of torture, but the Constitutional Court accepted the proposition that other crimes, including apartheid, are also crimes in South Africa because of their prohibition under customary international law. The Constitutional Court endorsed the prosecution of international crimes and crimes against humanity under Section 232 of the Constitution, noting, and the court quotes, "Along with torture, the international crimes of piracy, slave trading, war crimes, crimes against humanity, genocide, and apartheid require states, even in the absence of binding international treaty law, to suppress such conduct because all states have an interest as they violate values that constitute the foundation of the world public order. Torture, whether on the scale of crimes against humanity or not, is a crime in South Africa in terms of Section 232 of the Constitution because the customary international law prohibition against torture is the status of a peremptory norm," unquote. Paragraph 57. The Constitutional Court in the matter of National Commissioner concluded that the SAPS not only had the requisite power to investigate crimes against humanity but also a duty to do so, which duty arises from the Constitution. Paragraph 58. Accordingly, Section 232 of the Constitution provides an independent legal basis for the state to fulfill its obligations under the Constitution and under international law to prosecute international crimes, including those committed before 1994. Paragraph 59. South Africa is not alone in applying customary international law to pursue war crimes and crimes against humanity. Indeed, it is not even the first to do so on the African continent. Paragraph 60. Other African courts have also confirmed that crimes against humanity and war crimes may be prosecuted under customary international law, including the High Court of Uganda in the matter of Uganda versus Thomas Koyelo alias Latoni, cited in November 2017, and the Supreme Court of Gambia in the matter of State versus Yankuba Toure, which was cited in 2020, where the Supreme Court held that the common law read with the Constitution, and the court quotes, recognizes that customary international law is part and parcel of the common law, unquote, insofar as it is not inconsistent with local statute law. Paragraph 61. The Supreme Court of Gambia noted that the rights and duties flowing from the rules of customary international law will be recognized and given effect by the Gambian courts without the need for any specific act adopting those rules into Gambian law. As regards the principle of legality, paragraph 62, accusers refer to the principle of legality as being a ground for the inability of the state to prosecute the accused. This principle is often expressed as nullum crimen sine lege, meaning that an accused cannot be prosecuted for an action unless it was defined as a crime and punishable at the time it was committed. Paragraph 63. This court must determine whether apartheid was a crime under international law in 1982 because according to section 35, subsection 3L of the Constitution, an accused has a right to a fair trial, which includes the right not to be convicted for an act or omission that was not an offence either nationally or international law at the time it was committed. Paragraph 64. It is true that the rule against retrospectivity prevents prosecutors from pursuing crimes created by treaties if the crimes were committed before the date the treaty was ratified. However, if the state can prove that these crimes had passed into customary international law at the time they were committed, then the NPA may pursue these crimes under customary international law. Paragraph 65. This should not be a difficult exercise for the state in the matter in Kazu, as crimes against humanity have been crimes under international law since their codification in the 1945 Nuremberg Tribunal Charter. Paragraph 66. The International Covenant on Civil and Political Rights, which will be referred to the ICCPR, which was adopted in 1966, stipulates in Article 15, subsection 2, that a state party may indict, bring to trial, and punish any person for any conduct which at the time when it was committed was criminal according to the general principles of law recognized by the community of nations. Paragraph 67. Accordingly, Article 15, subsection 2 of the ICCPR allows prosecutors to pursue crimes prescribed under customary international law, even where such conduct was not domestically criminalized. Paragraph 68. There is considerable amount of foreign and regional case law that confirms that statutes of limitation do not apply to crimes against humanity and other core international crimes. Paragraph 69. Multiple other countries around the world have invoked customary international law to pursue the most serious international crimes, including crimes against humanity, without defending the principles of legality. Examples include cases from national courts in Argentina, Australia, Canada, Chile, Estonia, Germany, Latvia, Spain, United States, Uganda, and Uruguay. Paragraph 70. The accused claim that crimes against humanity committed before the commencement of the ICC Act do not fall within the exception as set out on Section 18, subsection 1 of Act 51 of 1977. Paragraph 71. It is a well-known rule of customary international law that the core international crimes of genocide, crimes against humanity, and war crimes never prescribe. Given the peremptory nature, use cogence, or compelling law governing customary international law, all states are under a duty to recognize and respect a use cogence norm. Rule 160 of the International Committee of the Red Cross, the ICRC, rules on customary international humanitarian law, which pertains to statutes of limitation, states that, and the court quotes, the principle that statutes of limitation do not apply to war crimes is set forth in many military manuals and in the legislation of many states, including those of states not party to the UN or European conventions on the non-applicability of statute limitations to war crimes or crimes against humanity. Rule 160 states further, prescription shall not apply to crimes under international law that are by their very nature imprescriptible. Paragraph 72. Due to many perpetrators of crime against humanity and war crimes that escaped the auspices of the Nuremberg and Tokyo tribunals after World War II, the United Nations adopted the Convention on the Non-Applicability of Statute Limitations to War Crimes and Crimes Against Humanity in 1970, which will hereinafter be referred to as the Convention on Statutory Limitations. The Convention on Statutory Limitations, as the name implies, prohibits application of statutory limitations, including the principle of undue delay to crimes against humanity. Paragraph 73, the Convention on Statutory Limitations recognized in its preamble that it is necessary and timely to affirm international law through this covenant on statutory limitations, the principle that there is no period of limitation for war crimes and crimes against humanity, and to secure its universal application. Paragraph 74, the Convention on Statutory Limitations applies to certain war crimes and crimes against humanity, including inhuman acts resulting from the policy of apartheid, irrespective of the date of their commission, and even if such acts do not constitute a violation of domestic law of the country in which they were committed. Paragraph 75, the Inter-American Court of Human Rights in Almanzar Arellano et al. Versus Chile, which was a decision in 1968, held that jus cogens transcends the law of treaties to include general international law, and it could not be otherwise because of its conceptualization as peremptory law. Even though the Chilean state had not ratified the Convention on Statutory Limitations, the Chilean state had to comply with this imperative rule and could not invoke the Statute of Limitations. Paragraph 76. The non-applicability of statute limitations to war crimes and crimes against humanity has been confirmed by multiple regional and domestic courts in France, Argentina, Italy, Spain, Belgium, United States, and elsewhere, as well as the European Court of Human Rights. Paragraph 77. South Africa has not ratified the Convention on Statutory Limitations. However, as mentioned supra, since the non-applicability of statutes of limitations to serious international crimes has become a peremptory norm of international law, South Africa is bound by such norm, whether or not it has ratified the Convention on Statutory Limitations or not. Paragraph 78. While South Africa is not a signatory to this treaty, the principles in the Convention on Statutory Limitations are part of customary international law. This is clear from the preamble to the Convention on Statutory Limitations. Paragraph 79. In the matter of government of the RSA versus Grootboom and others, 2001, Volume 1, Essay, page 46, the Constitutional Court held that international treaties that have not been signed, ratified, or enacted into South African law remain persuasive sources of law in the interpretation of the provisions of the Bill of Rights by virtue of the operation of Section 39, subsection 1, subsection B of the Constitution. Paragraph 18. Section 39, subsection 1, subsection B, and subsection C of the Constitution requires a court to, and the court quotes, when interpreting the Bill of Rights, a court, tribunal, or forum, subsection B, must consider international law, and subsection C may consider foreign law, unquote. Paragraph 81. The Constitutional Court in Government of the RSA quoted and applied the earlier dictum in the constitutional matter of S versus Makwanyane, 1995, Volume 3, Essay, page 391, where the Constitutional Court, dealing with Section 35, subsection 1 of the interim Constitution, stated that, and the court quotes, public international law would include non-binding as well as binding law. They may both be used under the section as tools of interpretation. International agreements and customary international law accordingly provide a framework within Chapter 3 that can be evaluated and understood, unquote. Paragraph 82, the 2000 final report of the Special Rapporteur on Civil and Political Rights concluded that, and the court quotes, statutes of limitation shall not apply for prosecuting violations of international human rights and humanitarian law norms that constitute crimes under international law, unquote. Paragraph 83, the basic principles and guidelines on the right to remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law, which were referred to the right to remedy principles, adopted unanimously by the United Nations General Assembly on 16 December 2005, provides in Chapter Roman numeral 4 that, and the court quotes, where so provided for in an applicable treaty or contained in other international legal obligation, statutes of limitation shall not apply to gross violations of international human rights law and serious violations of international humanitarian law which constitute crimes under international law, unquote. Paragraph 84. The crimes which the accused are charged with are imprescriptible. Based on South Africa's international obligations, there can be no time bar for the prosecution of crimes against humanity. The seriousness of crimes against humanity must be prosecuted irrespective of when they occurred. Therefore, there is no period within which such charges must be brought. A delay in prosecution is not a defense in law to these crimes, nor does it waiver the state's right to prosecute. Paragraph 85. The Constitutional Court decisions that I've alluded to have already found that A. The state is obliged to prosecute crimes against humanity, including apartheid-era crimes that occurred before the Constitution came into force. B. International law obliges the state to punish crimes against humanity. And C. The practice of apartheid constituted a crime against humanity. Paragraph 86. There are arguments before this court that Section 18, Subsection 1 of Act 51 of 1977 should not be interpreted to mean that crimes against humanity committed before the commencement of the ICC Act have prescribed under the 20-year rule, and that Section 18, Subsection 1G of Act 51 of 1997 must be interpreted to encompass all core international crimes, not only those that took place after the ICC's Act implementation in 2002, as reading the exception any other way would render the provision completely irrational. Section 18, Subsection 1, Subsection G of Act 51 of 1997 must also include all core international crimes even before 2002. These are the arguments. Paragraph 87. Interpreting Section 18, Subsection 1, Subsection G of Act 51 of 1970 in a manner that excludes war crimes, crimes against humanity and genocide that occurred before the 2002 enactment of the ICC Act is unfortunate, as it would fly in the face of accepted and established international law. It would effectively mean that only those who commit the crime of apartheid in democratic South Africa, but not before, would be able to be prosecuted for it. Not only is this absurd, but it would be plainly unconstitutional, going against the values set out in our own constitution, international law, and the interests of justice, and that Parliament would effectively have provided immunity for all persons who committed the crime of apartheid during apartheid, because evidently all those crimes would have happened in apartheid South Africa, which was obviously before 2002. Paragraph 88. However, as stated supra, the accused in this matter are not charged in terms of Section 4 of the ICC Act, but rather in terms of Section 232 of the Constitution, which provides an independent legal basis for the state to fulfill its obligations under the Constitution and under international law to prosecute international crimes, including those committed before 1994. The crimes for which the accused are being charged with were crimes under customary international law at the times that they were committed in 1982. As a result, this court has focused on Section 232 of the Constitution and the application thereof to the present charges. Paragraph 89. For crimes committed before 2002, Section 232 is the primary avenue for prosecution. Therefore, Section 232 allows for the prosecution of apartheid-era crimes under customary international law, and this court finds that Section 232 of the Constitution is a self-standing basis for prosecuting international crimes. The ICC Act as it stands explicitly prohibits prosecutions for acts committed before its entry. However, Section 232 allows for prosecutions of apartheid-era crimes under customary international law. Paragraph 90. The accused assert the entitlement to a fair trial, one that is conducted in a procedurally fair manner, not prosecuted without any unfair or improper or unlawful motive. However, they fail to provide any basis for the claim that their fair trial rights will be violated. The only reference to their claim is that the charges have prescribed under Section 18, Subsection 1 of Act 51 of 1977. Nothing is said about the lack of prescription in terms of customary international law. Paragraph 91. This court finds that crimes against humanity are part and parcel of South African law and not subject to any statute of limitation. The prosecution of the accused complies with the principle of legality under Section 35, Subsection 3, Subsection L of the Constitution, and that prosecution through Section 232 of the Constitution does not violate the principle of legality, as it does not retroactively create new crimes. Instead, it recognizes and enforces pre-existing crimes under customary international law, ensuring that perpetrators are held accountable for actions that were already considered criminal at the time. Section 92. According to the objection raised by the accused based on the principle of legality as being a ground for the inability of the state to prosecute the accused for a crime against humanity of murder, read with Section 232 of the Constitution, is without merit and is dismissed. Furthermore, the contention that the state's right to prosecute them for crimes against humanity under customary international law having lapsed is also without merit and is dismissed. A further objection is raised by accused 1 in regard to the objection to title to prosecute. Paragraph 93. The matter in casu was referred by the TRC to the NPA, and it is clear that there have been delays for many decades to prosecute this matter. Paragraph 94. Accused 1 objects to the title of the NPA to prosecute, given that the NPA and the Government of South Africa committed gross misconduct by engaging in political interference in the cases referred by the TRC to the NPA. Whilst accused one is justified in being offended by the past conduct of the authorities in suppressing the TRC cases, he does not explain how such conduct has violated his right to a fair trial. Paragraph 95. The same point was addressed by the full court in Rodriguez versus National Director of Public Prosecutions of South Africa and others, 2019, Volume 3, All South African Law Reports, page 962, where the Gauteng Division stated, and furthermore by the Supreme Court of Appeal in Rodriguez versus the National Director of Public Prosecutions and others, which is dated 2021, 3, All South African Reports at page 775. M. Rodriguez contended that the lengthy delay in commencing criminal prosecution, allegedly caused by political interference, caused him trial-related prejudice in terms of Section 35, subsection 3, subsection D of the Constitution, which justified a permanent stay of prosecution. Both courts expressed their dismay at the political interference, but concluded that the political interference in no way impinged on the right of Mr. Rodriguez to a fair trial. The appeal was dismissed. Paragraph 96. Accused one's counsel held a different view. He argued in the matter of Rodriguez, the court dealt with a permanent stay in a civil application which was denied and left the criminal court with a duty to address the issues. His argument is that the challenge in the matter in cause is different as it is based on the jurisdiction of the court and not on a permanent stay or crime. Paragraph 97. This court does not agree. While the Rodriguez case addressed the question of a permanent stay of prosecution, it also involved attempts to compel the NPA to make prosecutorial decisions in TRC-related cases. Whether delays caused by the state or not, the fundamental principles of the Constitution and Section 232 of the Constitution still apply to the matter in casu. Paragraph 98. The NPA's handling of the referrals from the TRC have been marked by delays and challenges despite the TRC's mandate being to promote accountability and justice. The failure to prosecute those responsible for apartheid-era atrocity has cast a long shadow over efforts at reconciliations, especially for families of the victims. Paragraph 99. In the matter in casu, the political interference, as regrettable and wrongful as it may be, will not deny accused one a right to a fair trial, nor is it deprived the NPA the title to prosecute this case or future cases arising from South Africa's past. Paragraph 100. Trial fairness is not confined to the position of the accused, but extends to society as a whole, precisely because society has a real interest in the outcome of a case. Section 7, subsection 2 of the Constitution mandates that the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. This duty extends beyond the rights of the accused to include the rights of victims. Paragraph 101. According, this objection is also dismissed. Paragraph 102. The charges on counts 2, 3, 4, and 5 are not problematic, as the indictments include the crime of apartheid as a reference to the crime under customary international law in terms of Section 232 of the Constitution, and not to the crime of apartheid as a crime against humanity as conceived in the ICC Act. Paragraph 103. Section 232 of the Constitution and the ICC Act are both mechanisms for prosecuting international crimes in South Africa, although they work in conjunction to ensure a comprehensive framework for addressing international crimes. They have different scopes and applications. The automatic incorporation of customary international law through Section 232 of the Constitution provides a basis for prosecuting any crime recognized under customary international law at the time of its commission, regardless of whether specific legislation exists for that crime. The result is that it covers crimes committed before and after the adoption of the ICC Act. Paragraph 104. This court accordingly allows the state to put the charges to the accused as per the indictment. That is the ruling of this court.
Yes, court, please.
Support, please.